This is the law part. Where a statute is ambiguous, we may consider a variety of extrinsic aids, including legislature history, the statute's purpose, and public policy. People versus Gonzalez. We must select the construction that comports most closely with the apparent intent of legislature with a view to promoting rather than defeating the general purpose of the statute, and avoid an interpretation that would lead to absurd consequences. In our case, all of our case, I'm sure. As in any case involving statutory interpretation, our fundamental task here is to determine the legislature's intent so as to effectuate the law's purpose. The well-established rules for performing this task require us to begin by examining the statutory language, giving it a plain and common sense meaning. We do not, however, consider the statutory language in isolation. Rather, we look to the statute's entire substance in order to determine its scope and purposes. That is, we construe the words in question in context, keeping in mind the statute's nature and obvious purposes. We must harmonize the statute's various parts by considering it in the context of a statutory framework as a whole. This is all citation, by the way. If the statutory language is unambiguous, then its plain meaning controls. If, however, the language supports more than one reasonable construction, then we may look to extrinsic aids, including the ostensible objects to be achieved and the legislative history. Los Angeles County Metropolitan Transportation Authority, Alameda, citation. Case history. Again, living my trauma. Case history. December 28, 2016, social worker Roger Rodriguez came to the home and was allowed in. The kids were not home because mother was remodeling. Rodriguez made an appointment to return in 1 week to reinspect after remodel mess was cleaned up by mother. Mother agreed. I might have to fix that. The very next day, he showed up unannounced, was still allowed to verify the kids were fine, and the mother was on her way to drop off the oldest daughter to school, so she left. Rodriguez was upset, and he wasn't allowed in. And mother was upset he broke their contract of the 1 week later revisit. Following this, mother called his supervisor and left a message requesting a replacement social worker. Social worker Rodriguez was not replaced, and he continued to stalk and harass mother and refused to give any supervisor's email addresses. January 20th, social worker Rodriguez, using Sacramento Sheriff's force when the children were not home again, to gain entry into mother's home, despite already confirming they were at the babysitters. Actually, no one was inside, and they knew this. For a whole week, mother did not hear any replies from the department, could not get a solid answer for detention of her children, and sought police assistance just to be told, be careful. CPS is like the law. January 27th, 8:30 p.m., social worker Rodriguez showed up with 3 sheriffs to serve the warrant they should have had a week prior. Mother tried to clear all allegations and clarify the claims with the Department of Sacramento. She had a new home to offer if the home condition was a problem, and she would give the child to father if she was the problem. No resolution was accepted or even heard by Sacramento County. The last hearing in Sacramento County, she was under the impression a trial would occur in Solano County upon transfer. A trial still had not occurred. Mother has been requesting formally and informally documents and evidence since before day 1. Now that she finally received evidence that proves the department lied about the hair follicle test, she is insisting, as she did from the start, for these heinous crimes against her family to be reversed once and for all. Appellant has requested discovery since January 20th, and her first disclosure to facts in the 342 petition given were during her extraordinary writ of habeas corpus. The plaintiff has contacted, which was a while ago, but like 2 years later, the plaintiff has contacted Quest Diagnostics, i3 Screen MRO, and CDAT drug testing screening in Vallejo, requesting any and all paperwork pertaining to hair follicle tests done on child K. None of these companies would give the appellant any paperwork. She emailed the documents in question to them, showing her entitlement to such disclosure, including identification, including in-person requests and phone calls, and every company stopped responding after initial inquiry responses. More law. Such evidence is material if there is a reasonable probability that, had the evidence been disclosed to the defense, the result of the proceeding would have been different. Responsibility for Brady compliance, NAICS team, lies exclusively with the prosecution. That's Brown. The scope of this disclosure obligation extends beyond the contents of the prosecutor's case file and encompasses the duty to ascertain as well as divide any favorable evidence known to the others acting on the government's behalf. Courts have thus consistently declined to draw a distinction between different agencies under the same government, focusing instead upon the prosecution team, which includes both investigative and prosecutorial personnel. Citation from Brandon. Brady disclosure requirement encompasses evidence known only to police investigators and not to the prosecutor. Thus, the individual prosecutor has the duty to learn of any favorable evidence known to others acting on the government's behalf in the case, including the police, and that includes social workers. This is because Brady places on the prosecution an affirmative duty to disclose evidence favorable to a defendant, and procedures and regulations can be established to carry the burden and to ensure communication of all relevant information on each case to every lawyer who deals with it. Since then, the prosecutor has the means to discharge the government's Brady responsibility if he will any argument for excusing a prosecutor from disclosing what he does not happen to know about boils down to the plea to substitute the police for the prosecutor and even for the courts themselves as the final arbiters of the government's obligation to ensure fair trials. As the Supreme Court emphasizes in Brown, the Supreme Court has unambiguously assigned the duty to disclose solely and exclusively to the protection those assisting the government case are no more than its agents. By necessary implication, the duty is non-delegable, at least to the extent the prosecution remains reasonable for any lapse in compliance. Since the prosecution must bear the consequences of its own failure to disclose, a fortiori, it must be charged with any negligence on the part of other agencies acting in its behalf. And that's Brown. A defendant may compel discovery by demonstrating that the requested information will facilitate the ascertainment of the facts in a fair trial. After the 36626 hearing, in which the appellant was present, and the docket even states such